Welcome to UCF Venture Launch. Today we're going to be talking about protecting your intellectual assets. So today is really just about understanding the different types of intellectual assets and some common pitfalls that startups can often incur. We wanted you to meet Jack Abid. He is, I've had the opportunity to work with Jack in the past. He is a plethora of knowledge around intellectual property. He's an absolute joy to speak with, and I think you're going to learn a lot from him today. And really what our goal is that we want to be able to inspire you to move forward. And if you are stuck, we want to help get you unstuck. I would love to introduce all of you to Jack Abid.
So my background, I went to school quite a long while, Georgia Tech and Jacksonville University, ended up getting my law degree from the University of Florida. My experience is primarily in patent procurement and licensing. So, these are the four primary forms of intellectual property that most companies will encounter. So copyright is probably the most common IP protection or IP asset in the United States. It protects creative expressions of work, of art, and once they're put in a tangible medium of expression, which in essence means it's kind of fixed. It's been fixed in some form, whether it's a computer program, whether it's music lyrics, whether it's a video, painting, you have some copyright the second you get it done. There's a whole slew of rights associated with a copyright. So the duration of copyright is quite generous in the United States. If you're an individual author, it's life plus 70. Corporate authors are work for hire. It's the earlier of 95 years from first publication or 120 from creation. The author by default is the owner. And for individuals, the person who fixed the work in the tangible medium expression, is the author. It's pretty straightforward. But in employment situations, it's the employer. And particularly for work, what we call work for hire scenarios. And if it's an independent contractor, if you're using someone on Fiverr and there isn't a written agreement in place, they are the owner of your copyright. And that's where you can commonly have an issue. Copyright protection is automatic. You're getting it as a matter of fixing it in that tangible medium, so you don't need to register it. But you can register it with the Copyright Office. And a lot of times, the standard policy recommendation from IP attorneys is, yes, register your copyrights. There are lovely benefits to registration. You get a public record, of course. You cannot launch copyright infringement in federal courts without a registration. And this can come up quite often as a thorn in the side of potential plaintiffs because the Copyright Office operates at the typical speed of the federal government. So when you file that application, it could be 9 months before you get your registration. So if you have an infringer and you want to sue them in court, you can't just walk to court. You have to get that registration, and you might have to wait 9 months, which is perhaps not optimum, particularly if someone is ripping off your copyrighted material. There is an expedited process, but it's still a month or two, and it's substantially more expensive. And again, there's also the benefit of statutory damages. If you register it within a certain timeline, you get those statutory damages. Statutory damages are great because they allow you to inflict pretty substantial costs on the defendant if they are infringing non-copyrightable material. So registration is helpful, and you should do it if you can, if it's within your budget. Common pitfalls, improper registration. It's kind of a bit of an art form, registering with the Copyright Office, what you register, how you divide it up, what type of work it's going to be, proper authorship. And you want, so it's something that you can do pro se, but you probably should. If you can hire an IP attorney, that would be optimum. Failure to hammer out the ownership issue, whether it's a work for hire or just a normal copyrighted work, because a lot of times folks will come back around wanting, to perfect that, and the contractor is not available, uncooperative, or has been terminated. And so as a startup or as your venture as a small company, you want to avoid these type of pitfalls because they can just be costly, because no one's going to drag you into a court, but they'll drag a license fee out of you that will be onerous and difficult to internalize, and it will be for something that perhaps you didn't need. So when you're generating any of your materials, websites, so on and so forth, you need to be careful of copyrighted material. Trademarks are source identifiers in essence. They identify the commercial source of a product. how do you get a trademark? There needs to be it needs to be based either on inherent distinctiveness or acquired distinctiveness. And in essence, there needs to be a standard. It needs to be different from the existing marks in the field. So when you're picking a trademark for your company or a name for your company, there's kind of a continuum. The more descriptive it is, the less likely they're going to give it to you. Because remember that kind of balance between the First Amendment and commercial efficiency. Generally, when you actually file your trademark application for registration with the USPTO, they either have to give you the registration or reject you. And one of the ways they can reject you is that it's too descriptive or it's generic. We're not going to allow you to box out the English language. We want things that are a little bit more arbitrary, so it's less of a problem for expression in the English language. So trademarks, how do you get them? So by using, just like copyrights, there's a common law right generated from just use. The second you slap your name on your product and you're out there in commerce, you got some rights. They're more localized though. So common pitfalls, again, similar to copyright and proper registration, it's an art form. I don't recommend pro se filings at all. Hire a seasoned trademark professional. Trade secrets are great because in essence, you don't really need to do much other than keep it confidential and secret. You actually maintain the secrecy via non-disclosure agreements, employee manuals. It doesn't require a formal registration process. And the advantage of trade secrets, is that there are no timelines. There's no expiration. Back to the requirements, you do need to take reasonable steps to make sure it does stay secret. And again, that would be non-disclosure agreements, marking of confidential information. So common the trade secret pitfalls: failure to paper up employees, which is non-disclosure agreements, non-competes, marking things confidential. Be careful about NDAs because you can't have onerous NDAs, and if you want to make sure you get an NDA that is in line with the state, the laws of the state that you're going to be operating in. Also, lack of security protocol. I mean, you need to keep your materials confidential using reasonable commercial methods of security. So which brings me to the most popular IP form, patents. There are three types of patents. There's plant patents, design patents, and utility patents. Plant patents are generally quite rare, and for basically new hybrids new hybrids of plants and that you come up with. Design patents are visual, ornamental characteristics, in essence, the look and feel of a product. And then the more common one is the utility patents. And those protect any new useful process, machine, article of manufacture, or composition of matter, and it's quite broad. And then there's also the provisional patent application, which is a subset of utility patents. So most folks don't understand exactly what a patent is. They know it covers technology, but they sometimes think it's like a monopoly on the idea and the subset of the idea. But in reality, a patent grant is a negative right. It doesn't actually allow you to practice your invention. It allows you to prohibit others from making, selling, and using or offering for sale your product or process, which is claimed in the issued patent. So patent term is 20 years from the earliest priority date or filing date, and 15 years for the design patent. Your copyright, trademarks, patent rights are territorial to the United States and their territories. So you would need to get that protection in other jurisdictions. So how do you get a patent right? And so this particular patent requires a filing, just like formal copyright registration and trademark registration. You have to file an application, but there is no common law rights. So if you don't file, you don't get anything. You can, at most, you can maintain it as a trade secret if it's something you can maintain as a confidential advantage. The preparation and filing stage, which takes 6 to 8 weeks. So that's the interview with the inventor, the discussion, the initial draft, revisions, finalization, filing, getting inventor's declarations and assignments. That usually takes 6 to 8 weeks. And then there's a wait. About the current average is a little under 15 months, but that's what the USPTO says. But it varies depending on your technology. And the more complicated the technology, the longer the wait. For example, software, business methods, Semiconductor processing can be 4 years. So that's 4 years from your filing to when you actually hear from the USPTO. So once you get a first response from the USPTO, and again, just like trademarks, either they got to reject you or give you a patent. So you either got to get a notice of allowance, which is good, which means you effectively pay an issue fee, and within 4 months, you would get a issued patent, or you get an office action, which includes a rejection. And when they reject you, they're rejecting you on the standards for patentability, which are novelty and non-obviousness. And novelty is pretty straightforward. It's got to be new. And then the non-obviousness is kind of the rubric that we use in the United States to decide whether that difference from the old tech and your tech is big enough to be worthy of a patent. So if you take their average 15 months, you're starting to look at 3 years from the day you meet that patent attorney to the time you actually have a patent in hand. So why do you get patents? Why do you file a patent? Particularly for a venture, they're the most expensive IP assets. So people ask all the time, why should I care? Well, they're assets. They're intangible. They're valuable for businesses. Why? Because people, when you go to do a seed round of funding, a lot of times they want to see whether there's a potential for patent rights down the line. Patent enforcement's expensive. You're not going to do it, but your successor or the company that perhaps decides to invest in you or purchase your company will have those assets and could utilize them and enforce them for you down the line. And technology businesses, this is totally bread and butter. You almost invariably need to have some form of patent rights, either pending or potentially on the horizon. And once you get them, even if you're not interested in enforcing them, you can transfer them. They can be leveraged for loans. They can be sold if you need to liquidate the company. And if you get absorbed by the parent entity down the line, which would be a lot of times might be the exit strategy for your venture, it's included as an asset when they acquire your company. So common pitfalls, disclosure in all forms. And the reason it is a patent, once you disclose it, you have a time clock to pursue patent rights. In the United States, you have 1 year. In some jurisdictions, there is no grace period. So if you disclose it, you're surrendering your potential patent rights. You want to protect your patent rights if at all possible. Even if you don't have it in your current budget to pursue them, you should keep it confidential until you evaluate it for patentability.
I'm the director of the Office of Technology Transfer. What we do is we manage the intellectual property that's developed at the university, and we protect it, we market it, and we license it to industry partners. So everything that Jack was talking about is super relevant to what we do, and he gave a fabulous introduction. So when an invention and work comes in, what we do is an assessment of that technology, of that invention, and look to see what would be our protection strategy. So specifically, we look at what are our reporting requirements. So some of the inventions that are developed at the university are sponsored by outside agencies. It could be sponsored by a federal agency, or it could be sponsored by a private industry partner. We also then really do an assessment of the technology. We look, as Jack was mentioning, for something to be patentable, it has to be novel and non-obvious. So we look to see what is the novelty element of what is being disclosed to us, and how broadly would we be able to protect it. We look at the market size. We look to see if our researchers need additional assistance in bringing in funding to develop the technology further. And we start to think about what is the right intellectual property protection path? Is it patenting, copywriting, or trademarking? We have very few trade secrets. We don't like to do trade secrets. We are a public university. Our mission is to publish and to disseminate research results. So it just does not go with our mission. Not only our mission is to share information, but we also want to be able to, for students and postdocs, to leave the lab and be able to use that know-how, to use that information that they've gained as part of their research experience. And then we also look to see we talk to the inventors to determine what is a possible commercialization path. Are they interested are the researchers, the faculty interested in spinning out a company? Are the students or postdocs interested in spinning out a company? Then, that's something we'll think about. Or is this technology more suitable to be licensed to an external existing company that can get it to market very quickly? Yeah, this is where I just spent most of the time talking about what is the assessment that we do when the inventions first come in. And you can see, I talk about regulatory requirements and all these other things. We have a technology commercialization committee that meets once a month. And a lot of the team members from Tech Transfer are in this presentation, and they're the ones who lead this process. So our technology commercialization committee looks at this assessment that's prepared that we just talked about, all those different factors, and makes a recommendation as to whether the university should take title to the invention. And so if not, it's possible we can put it on hold and talk to the inventors to see if they're going to get more data, which will make it a little more meaningful, more protectable, more valuable. Or if the inventors are not going to continue to pursue it and there's really no interest, we could waive the IP rights to the inventors. If it's not federally funded, we can just abandon it. Or of course, we can choose yes and go ahead and decide to protect the technologies. So then we'll do a deeper dive. We'll do a deeper market and business analysis, and we look at the market opportunity, the competitive landscape, to see if some of the competitors could be actually partners that we could work with to license the technology. We look at the industry and what is the path to market. We look at the stage of the development. We talk to our inventors to see if they want to spin out a company and potentially apply for small business grants that are out there. We also have the I-Core program, and it's a great way to really quickly assess if there's a business opportunity and to validate it before you really spend a lot of time and money in spinning out a company and writing a business plan and securing space and all kinds of stuff. You can just validate the business opportunity by seeking out customers and identifying if what you have is truly a solution to a need that they may have. So then, having done all of this, we come up with a commercialization strategy. And I mentioned, there's opportunities to maybe spin out a company or to license to an external company. If we do spin out a company, we have other resources at UCF that are provide coaching, and we have the incubation program. Some of the coaching is what you have probably experienced here through Venture Launch with Kelli, with meeting one-on-one with you all. So there's a lot of great resources. Once we license, we're not really finished. We continue to work. We want the intellectual property that we develop to be valid and valuable, of course. So we want to make sure that we protect it before it's published. When we talk to our researchers, they often think of publication is, think of it narrowly as as a manuscript, something in a journal, in a scientific journal or technical journal. It's much more than that. It can be a poster presentation at Student Research Week. Even if there's a confidentiality obligation, it could be viewed as already being a disclosure that defeats patent rights. So we definitely want to protect before anything is published. We want to make sure that we have correct inventorship, and we want to make sure that we are citing accurately what the funding sources are, especially federal. Otherwise, the patent can be invalidated unless it's corrected. So we want to make sure, and inventorship is a complicated topic that we don't have time to get into, but we absolutely want to make sure we have the right inventors. Just because somebody's a co-author in a publication does not mean that they're a co-inventor on a patent. We also want to make sure that we understand all the different references. We have an obligation to the patent office to inform the patent office of anything that we think is materially related to our invention. So when we do those assessments that I mentioned and we find what else is out there, we provide anything that we find, any references that we find, we provide them to our patent attorneys so that they will file them as references when they're filing the patent applications. And then, the last part is we want to protect as broadly as possible. So when we're talking to our inventors, we want to know what else can it be used for. All right, I will stop there. I know we're over time.
We are over time. Svetlana, thank you. Jack, thank you very much for making the time and putting the materials together to cover this super important topic. Whether you're in a patent pending status or you're thinking about getting a patent, you might want to think about copyrights and trademarks and trade secrets, especially if you anticipate that you're going to be going out and trying to get funding, because investors love having things patented and knowing that things are protected. It's definitely an advantage as a startup company.